Implied terms. From your understanding as a law student, which statement is true? Courts are generally eager to imply terms of a contract, or courts are generally reluctant to imply the terms of a contract. As discussed in previous lectures, the courts generally consider their role to be that of an interpreter of contracts rather than a maker of them. The more frequently the terms are implied into a contract, the greater the extent to which the courts has created the contract rather than merely interpreted it. Now another question. Do courts need to imply terms in some situations? Are you nodding your head right now? The purpose of implied terms is often to supplement a contractual agreement in the interest of making the deal effective for the purposes of the business, to achieve fairness between the parties, or to relieve hardship. So yes, courts do need to imply terms in some situations. Courts will imply terms into contracts either by operation of common law or by statute law. Effective October 1st, 2015, Consumer Rights Act 2015 has replaced several consumer-related legislations, including the Sales of Goods Act 1979. The terms of a contract entered into before October 1st, 2015 will still be governed by previous legislations. Therefore, for the purposes of this lecture, we will discuss the situation before the enactment of Consumer Rights Act 2015. We will discuss this new act in the next section in detail. So, most commonly used examples of statutory implied terms before the enactment of Consumer Rights Act 2015 are Sections 12 to 15 of Sales of Goods Act 1979. The most relevant section is Section 14 of the Sales of Goods Act 1979, which stated that goods sold by a seller in the course of his business shall be of satisfactory quality, not merchantable quality. The purpose is to provide a standardization of terms in certain kinds of contracts. It also provides a measure of protection for certain categories of parties, such as consumers. Detailed knowledge of these sections at this time is not required. You should keep in mind the fact that these terms are only implied by statutory law, which means that it is open to the parties to defeat these implications, either by their course of dealing or by their express agreement. However, keep in mind that only in very limited circumstances can the parties agree not to be bound by them. Only business contractors, as opposed to the consumers, are allowed to agree to modify these implied terms, and then only if the courts think that it is reasonable. Remember that the objective of the implied term here is not to make the agreement work, but to protect the purchasers, and in particular consumer purchasers. So remember that the statutory implied terms go further than common law in imposing obligations on the parties in the interest of protecting the weaker party in a sale of goods transaction. So now let's see how terms are implied in common law. Think of a situation where the vendors of a certain type of good always paid the broker's commission with regard to the sale. Absent a term to the contrary, courts will imply such a term into this type of a contract. So, courts tend to imply terms where an established trade usage can be demonstrated in commercial contracts. Another situation where terms may be implied by law can be due to the nature of the relationship, such as landlord and tenant, or employer and employee, etc. I encourage you to read Malik vs. BCCI 1997 and Liverpool City Council vs. Irwin 1976. In Malik vs. BCCI, the bank had operated corruptly, and it was held that there was an implied obligation upon an employer not to conduct his business in a manner likely to destroy or seriously damage the relationship of confidence and trust between employer and employee. The courts may also imply terms into the contract to give effect to what appears to be the unexpressed intention of the parties. The test basically is to see that without such a term, contract was effectively unworkable. The test is called Moorcock Test. Moorcock Test was driven from a case where the claimant moored his ship at the defendant's wharf on the River Thames. The River Thames is a tidal river. The ship became damaged due to uneven surface and rocks on the riverbed. The claimant sought to claim damages from the defendant, and the defendant argued that there was no provision in the contract warranting the condition of the riverbed. The court implied a term, in fact, that riverbed would be safe for mooring. The court introduced the business efficacy test. That is, the term must be necessary to give the contract business effect. This type of implication is called implication in fact. The business of the wharf owners could not be carried on if incoming ships did not believe that the wharf was reasonably safe to dock in. The owners were the only party who could have known that the wharf was safe, and so it was necessary to imply an obligation to take care that it was safe. And last but not the least situation where the term may be implied in law is the one where courts feel the need to apply officious bystander test. This simply means asking a question. What if an imaginary officious bystander had suggested the term at the making of the contract? And if the likely response of the parties would have been, of course, then the courts should imply that term. This means that if the term that the officious bystander had suggested was so obvious that it should go without saying, then the courts should be prepared to imply the term.